Good morning. Hoş geldiniz. My name is Arda Beşkardeş, and I'll be presenting the sequence of events today. I'll be your MC for the time being. First of all, I would like to welcome all of you to the first Turkish-American Law Conference in New York City. And I would like to thank the New York Law School for opening their conference room for this beautiful event. And I would like to extend a special welcome to our Turkish-American law students. It's a cliche. I'm going to start the day with a cliche, but you guys are our future. You guys are our future. And we would like to think that we will help you in achieving your future in one way or another as mentors and in the future as colleagues. And we'll try to teach you through our accomplishments, our failures, our mistakes, missed opportunities, whatnot. So a special thank you to all of our students. We are Turkish-American legal professionals. We are part of hyphenated Americans. But most America is actually hyphenated. From the Italian Americans to the Scandinavian Americans of the Great Plains and the Midwest, most of America is made of hyphenated Americans. And as Turkish Americans, as our community, we are no exception. It's a cliche, but America is a melting pot. I started with cliches, I'll go on with cliches. But Turkey actually was the original melting pot. It's a bridge. It's a geographical bridge between Asia and Europe. And civilization after civilization, for thousands of years, passed through Turkey. Some just passed through, others remained. It created a beautiful cultural mosaic. It was the original melting pot. We actually became the latest residents, I should say, in 1071. It's actually an interesting date. It's about 5 years after the Battle of Hastings. So I guess those period in history was a period of mobility for many civilizations. But nevertheless, we've been calling Turkey home. Some people call it Asia Minor, some people call it Anatolia, but it's our home. And we've been calling it home for 1071. With this cultural mosaic, with this diversity, we are a very resilient, very resourceful people. And there is no problem, or there is nothing that we cannot solve as the Turkish people. I have full faith and credit in my people. I always did, I always will. And with our resilience and with our resourcefulness, some of us, when we heard that there may be a conference or there's need for a conference, we rolled up our sleeves and we decided to get together and get this done. That was 7 months ago. And we worked hard. I tell you, we really worked hard to come to today. And I would like to thank all of you who were instrumental in putting together this beautiful event, this beautiful conference. But I would also like to note this. When I refer to we, I'm not referring to a legal entity. There's no entity that I can refer to as a we right now. We were just volunteers. Anybody who knocked on the door, anybody who said, do you need help, was part of us. We would like that to change. We believe in unity. We believe that the legal profession is extremely crucial in the United States, and we believe that Turkish-American legal professionals should come together. If you look at the numbers, almost 40% of the entire U.S. Congress is made up of legal professionals. If you look at the numbers, almost all state legislatives are predominantly made up of attorneys. A good majority of all the U.S. presidents were, in fact, legal professionals. I would like to see Turkish Americans in the United States Congress. I would like to see Turkish Americans, more Turkish Americans in the U.S. judiciary, in the state systems, in all parts of legislative and executive branches. We should be there. And hopefully our student friends and some of our colleagues will make it there. But to make it there, we need support, and we need to support each other. We also need more pro bono activities in our community. We also need more legal support in grassroots and legislative efforts through legal professionals in our community. There are so many things that we need. To do those things, we need to unite. We need an association. And today we'll talk more about that later on in the day. I hope the next time that we're in this room, I hope that when we refer to we are actually referring to all of you. Because today this conference is about you, about the Turkish-American legal professionals and the Turkish-American law students. It's not about us. And hopefully all of you will join our ranks, and hopefully we will be able to put together a meaningful association that will help everybody. With that in mind, we'll have lots of sessions today. We have wonderful speakers who agreed to join us, who agreed to give presentations. And it will be a fun but an intensive day. That being said, I would like to start the conference with a couple of speeches. First and foremost, I would like to invite Ms. Sevil Özışık. Sevil is an attorney, as most of you know, who practices in New York City. And she is also on the advisory board. She's an advisory board member for the Turkish Citizens Abroad, who was one of the sponsors of this conference. Sevil, would you please? Thank you.
Thank you, Arda. Good morning. Dear Consul General Levent Bilgen, U.S. Coordinator Muhlis Kaçar, esteemed speakers, and to all attendees. Welcome to the first Turkish-American Law Conference. As a Turkish-born attorney living and practicing in the United States for more than 15 years, I'm proud to say that I enjoy my practice and being an attorney and truly being a part of the legal community in the United States. However, I've never felt this this kind of professional satisfaction until I was able to get together with the most generous and visionary Turkish-American attorneys and students to put together this first Turkish-American Law Conference. It is still amazing to me that we've been working together since April of last year to organize this conference. And every member of the group has spent countless hours without any personal expectations or requests. I stand in front of you today with the most genuine belief that our future is great and Turkish-American attorneys are now ready to take the next step, to really work together and to start our own professional association. It is time to be a part of a much larger network, to work together, to help and support each other, and serve for our joint interest when and wherever needed. I'm proud to be a Turkish-American legal professional, and I would like to thank every volunteer member from the bottom of my heart. I have never envisioned that my position with the Foreign Advisory Board of Turks Abroad would bring me the opportunity to start the network among the Turkish-American legal professionals. And I would like to thank them sincerely for their support and contributions since the beginning. Thank you again. Thank you, Muhlis Bey. The Turkish General Counsel in New York has also been most insightful and helpful in supporting our initiative, and their contributions have been essential. It's also been noteworthy that almost all the Turkish-American NGOs have been directly or indirectly giving us their support to organize this conference. Dear Murat Kaval Bey and dear Celal Seçilmiş, çok teşekkürler. Thank you very much. I'm very happy to state that, yes, we can get together for the right purpose and agenda. This community of legal professionals has the vision and tools to accomplish much more in future as we continue to work together. We are also honored today to have with us exceptional legal minds from public service and government, academia, and private sector to share their expertise, and our program would not be the same without their presence. Thank you for being with us today and supporting our efforts. Lastly, I wish to point out that the future of Turkish-American professionals are the Turkish-American students who have registered for our conference today with great numbers, more than 70 of them, that they will be joining us throughout the day. The students, as the next generation of Turkish-American attorneys, judges, and politicians, will take us to different places and change how we live, work, and collaborate. I sincerely hope some of you today will discuss your work and careers with them and will informally serve as their mentors for these soon-to-be young Turkish-American legal professionals. I really hope you will enjoy the program and you will make new or renew connections during the course of today. As this is our first conference, we welcome your feedback and ideas so that we move forward together and we continue to improve our programs to make them as meaningful and impactful as possible. Thank you again for being here today and being a part of our conference.
Thank you very much, Sevil. We would like to continue with a special message from Judge J. Karahan. Judge J. Karahan, a second-generation Turkish person, is actually a Harris County Criminal Court judge at number 8 Criminal Court in Texas. And we have a special message from him through video. He was planning to be here, but because of reasons beyond his control, he couldn't. But he was very grateful in submitting this video. So,
hello, my name is Jay Karahan, and I am judge of Harris County Criminal Court at Law number 8. And it is my privilege and honor to welcome you to the first annual Turkish-American Law Conference, which has been generously sponsored and supported by Yurtdışı Türkler ve Akraba Topluluklar Başkanlığı YVDK, Danışma Kurulu üyesi, the Turkish Consul General's Office in New York, and the esteemed New York Law School. I would be with you today but for my necessary attendance at a sentencing conference with my fellow judges in San Antonio, Texas. The conference you are attending is a seminal event in the life of the Turkish-American bar, which grows steadily each year. By your attendance, you are demonstrating a commitment to connect with each other and those interested in the success of our Turkish-American lawyer colleagues and learning more about common professional interests and concerns. Tebrikler, I salute you. At this conference, you will also have the opportunity to formalize a Turkish-American Bar Association. I encourage you to do so for many reasons. First, you will grow professionally and increase your knowledge of the law that will help you serve your clients. Second, you will increase your networking skills with your lawyer brothers and sisters, and by doing so, grow your practice. Third, by actively participating in this bar association, you will gain visibility with other more established state and national bar associations, as well as the courts and other governmental bodies, which can only strengthen the bridge between Turkey and the United States. I am certain that you can and will find many more good reasons to establish this organization, and I look forward to becoming a member of the Turkish-American Bar Association. It has been 11 years since my investiture as judge of Harris County Criminal Court at Law Number 8 on January 1st, 2003, and I'm now in the 4th year of my 3rd term in office. I'm running for re-election in 2014, which will be my 4th term in office, and if I'm successful, it will allow me to retire as a senior trial judge in Texas in 2018. At my investiture in 2003, the then acting Turkish Consul General of Houston, Honorable Ali Arsin, spoke at this ceremony, and we were all astonished to learn from him that I was the first person of Turkish heritage to be elected to such an office. I hope not to be the last, and I urge you to stay active in local, state, and national politics where you can make a difference in your communities as well as strengthen the ties between the United States and Turkey. Our two industrious nations value hard work, education, and individual liberty. As U.S. lawyers, you are on the front line of defending the rights and liberties of your clients. And as men and women of Turkish heritage, we have many centuries of advantageous historical experience, achievement, and progress behind us. Please come together now as a community to move these great ideas into the future as we strive to make the United States and Turkey shining beacons of progress, human achievement, and liberty. I send my warmest regards and best wishes for a successful conference.
Well, I would like a round of applause in absentia. Judge Karahan was so great. We were so grateful for his speech, even though in absentia he didn't let us down. And we share a sentiment that hopefully there will be more Turkish Americans in the judiciary very soon. I would like to, at this point, invite Mr. Muhlis Kaçar. Mr. Muhlis Kaçar is the coordinator for Overseas Countries Division, responsible for United States, Canada, and Australia, for the presidency for Turks abroad and related communities. Mr. Muhlis Kaçar.
Such a great message from Judge J. Karahan. So, dear Consul General of Turkey in New York, Levent Bilgen, dear judges, lawyers, academics, people of law, students, ladies and gentlemen, I'm here to represent the Office for Turks Abroad, which operates under the Prime Minister of Turkey, an office that is entitled to provide emotional and technical support whenever it's necessary for the citizens who live abroad. Today, I am privileged and honored to be able to speak in front of such a distinguished audience. Together with my co-workers who are with me today, we brought the well wishes of our people in Turkey as well as our president of the Office for Turks Abroad. I wish we could have brought the warm weather that we enjoy in Turkey, which I'm sure you could use it here in New York nowadays. Ladies and gentlemen, this conference is the first of its kind where the Turkish-American lawyers from all walks of life came together and worked hard together. Speaking on behalf of our presidency, what we value the most is that this event is not an idea of a single person, group, or association. Rather, it's the product of a teamwork. So let's take this to the next level, as Judge J. Karahan stated as well, perfectly, to the next level where hopefully it will lead to establishment of a bar association of Turkish-American lawyers so that the Turkish-American community could have a strong representation in that sense. A strong community, for that matter, means a strong society altogether for the United States where different colors of humanity live in peace and harmony. So as the metaphor goes, initiate like a Turk, proceed like a German, and conclude like a British. And when you add to that the American perseverance, there you have the magic solution for success. In the end, I'd like to thank all the American Turkish umbrella organizations for their unconditional support for this event. But more importantly, I'd like to thank all the volunteers, without whose efforts this conference would not have been materialized. Again, I'd like to personally thank to those volunteers, which I will name them as follows without a particular order. Sevil Özışık, Ayhan Bey, Murat Bayram, Arda Beşkardeş, Merve Gür, Mehmet Fırat Polat, Remzi Güvenç Kulen, Petek Günay, Ekrem Ergün Emeksiz, Celal Seçilmiş, Ali Çınar, Murat Kaval, Utku Kurtmer. And last but not least, I'd like to thank Honorary Levent Bilgen and his staff at the consulate for their superb supervision throughout the whole process. Let the history take care of the rest, and thank you and enjoy the event. Thank you very much.
Thank you very much, Mr. Kachar. Without your office's help, none of this would have been possible. Now I would like to introduce somebody who I admire a lot. The Honorable General Consul of Turkey in New York, Mr. Levent Bilgen. Thank you.
Ladies and gentlemen, good morning. I wish to express a very warm welcome to all the esteemed participants of the Turkish-American Law Conference. I also would like to acknowledge the audience that has shown a highly keen interest in this event. A conference such as this one is being held for the very first time. This significant endeavor has been made possible through the invaluable and collaborative work of the team of organizers, the Turkish-American lawyers who volunteered for the task. We also need to recognize the generous support of the Presidency for Turks Abroad and related communities of the Office of the Prime Ministry of Turkey. Its dedicated team has made itself available since the inception of the idea to bring forward the network of Turkish-American lawyers. Today's gathering is important as Turkish and American lawyers and academicians are not only here together as colleagues, but also through their collaborative effort, a platform for discussion and action could be possibly established on international as well as general issues that are before the Turkish-American community. Indeed, your presence here is valuable and strengthens the network of Turkish-American lawyers. Your active involvement will encourage new generations to join ranks and also facilitate efforts to service your respective communities. Your leadership will add increasing value to the further development of the Turkish-American community. In closing, I would like to thank in particular Ms. Sevil Özışık, honorary member of Overseas Citizens Advisory Board of Turkey, for her tireless efforts in managing the preparations for today. She was certainly not alone, and I sincerely thank all members of the organizing committee who demonstrated resolve and the team member mentality to further the preparatory process. We are also most appreciative for the visit of a highly distinguished delegation from Turkey. Thank you for being here today. We are certainly indebted for the fundamental support and encouragement of the Presidency for Turks Abroad and related communities, represented here by Coordinator Mr. Muhlis Kachar. Welcome again, and thank you all for making this conference possible. Much success to you.
Thank you very much, Mr. Bilgen, Honorable Consul of Turkey in New York City. We are running about 30 minutes late. It's the first one, please excuse us. So what I would like to do is, if it's okay with everybody, we'll skip the coffee break and go straight to our first panel, if that's okay with everybody. Also, before we do that, I want you to do something. I want you to look around the room and throughout the day meet everybody that you don't know. But right now, look around the room and think about the people who should be in this room, but for whatever reason, maybe because they didn't hear about this event, or maybe they had other engagements, who are not here. And give their names to us. If you have the contact information, give the contact information to us, because we would like to reach everybody who's involved with the legal profession. And with that in mind, I would like to invite our first panel, Mr. Weiss, Mr. Barton, and Mr. Sullivan. Our first panel is going to be international trade hot topics. And Turkish-American trade is actually growing significantly, and hopefully it will be growing more rapidly in the next couple of years. And trade issues are becoming more and more important. So we decided that we must have a panel on international trade and international business issues. Our moderator on this panel is going to be Mr. Sidney Weiss. Mr. Weiss is an international business attorney focusing on trade, commerce, all kinds of international transactional matters. Before that, he was a trial attorney with the U.S. Department of Justice. And his company, his firm, actually represents everybody from Fortune 100 companies to small startups and other entrepreneurs. So without further ado, I would like to pass it on to Mr. Weiss so he can talk more about himself and introduce his panel. Thank you.
Thank you.
We got exactly 50 minutes
Okay.
as planned from now. So push everything by 20 minutes on your schedules. Hopefully this will be the last delay.
Right. Thank you very much, and thank all of you for coming. What we're going to discuss today is international trade as it affects Turkey, both inbound into the United States, how transactions involving Turkish companies, Turkish people coming into the United States are subject to United States laws, and how that should be dealt with, how that should be planned for, etc. And my two panelists will discuss that and review those aspects of it. Before I introduce them, I'd like to spend a few minutes to talk about another aspect of international trade, and that is the extraterritoriality of United States trade laws broadly conceived. And many people, most people in fact, do not know that laws passed in the United States for the benefit of U.S. citizens, U.S. businesses, etc., have an effect abroad, have an effect on foreign citizens abroad, foreign nationals abroad, even though they don't have anything to do with the United States, and many of them don't transact business in the United States. And I want to discuss four laws in particular. It's going to be very brief because we have very little time. And those are the Foreign Corrupt Practices Act, the export control laws, the Anti-Boycott Act, and anti-dumping laws. All have extraterritorial effect. With the Foreign Corrupt Practices Act, the law there prohibits any U.S. citizen or green card holder, and for all these laws, a U.S. person is defined as someone who's a citizen or has a green card. And so you're a U.S. citizen even though you have dual nationality. Even if you're a Turk and you have a green card, you're considered a U.S. person. For the purpose of those laws, you're affected by them. So it affects U.S. persons abroad, and it affects people who work for U.S. companies abroad. And it prohibits anyone from giving money or anything of value to any governmental person or entity, or a quasi-governmental person or entity. So you can't bribe a government official. If you work for a U.S. company or if you're a green card holder, you can't do it. And if you work for a U.S. company, whether or not you are a U.S. citizen or a U.S. person or not. The fines there are enormous. People go to jail for violations of those laws, so you have to be very careful. The next one, in a brief overview that I want to discuss, is export control laws. In export control laws, the effect is not only on U.S. persons abroad, but also on U.S. businesses abroad, and also on U.S. technology and products abroad. So if you have a product which incorporates U.S. technology, wasn't made in the United States, wasn't made by a United States company but is sitting in Turkey, and you want to sell that on to Iran, for example, you cannot do that under U.S. law, whether you're a U.S. citizen, whether you work or person, or whether you work for a U.S. company. You can't do that because it incorporates U.S. technology. A violation of that, again, is a criminal offense. Mostly monetary and civil sanctions are imposed on it, but people are affected by it all over the world, and you can't do it. A real switch on the extraterritoriality of those laws, of export control laws, is that even sitting in a room like this, if we're talking about controlled technology or controlled U.S. services, and one person here is not a U.S. citizen or a green card holder, that is deemed an export. So if I'm talking about controlled technology to someone who's not a U.S. person sitting in New York City, I violated the U.S. export control laws because it's considered a deemed export. So people have to be careful about that. The third law, major law, which affects extraterritoriality is the anti-boycott law. There, it's less of a risk than these other laws that I've spoken about. There, again, any U.S. person or any person working for a U.S. company can't comply with a foreign boycott request, and when it's reported to that person, whether abroad or in the United States, they've got to report it to the Department of Commerce, and a failure to report is a violation of U.S. law, again, subject to penalties. There, we really don't have a lot of criminal sanctions, not a lot of criminal convictions based on that. And the final law that I want to talk about before I turn it over to the rest of the panel is United States anti-dumping laws. Those laws and countervailing duty laws, those laws really affect trade only and are specifically civil. What those laws do is they impose duties upon products coming into the United States from abroad if the product abroad was either subsidized by the foreign government, and then the subsidy is countervailed by an equal duty coming into the United States. Whether that's legal under foreign law or not, it's subject to a duty coming into the United States. The product is subject to a duty coming into the United States. That's countervailing duty law. And if the product is sold, let's say a product is sold in Turkey for $100, and the same product is sold to the United States for $80, and it's sold for $80 to the United States because that's all the market can bear here, well, then that product is considered dumped in the United States for 20%, and a dumping duty is imposed on it, whether or not the Turkish company made profit on that. So all these aspects, all these U.S. laws, even though they're made for U.S. people, really affect commerce and business with the United States from outside the United States, whether or not people know about it or don't know about it, and they should really pay people abroad who are doing business with the United States or thinking of doing business with the United States, or who may ever become subject to the jurisdiction of the United States in terms of the criminal sanctions, should really think about it. So with that overview of some statutes, U.S. statutes, which have extraterritorial effects, I'd like to introduce the panel today. Over on my far left is Michael Sullivan. He was educated at Providence College and at Fordham Law School. He's an expert on international trade, litigation, arbitration, and counseling matters regarding banking, trade finance, securities, forfeiting, etc. He's been recognized as one of the finest lawyers in the United States, and he'll be giving us an overview of U.S. law as it affects Turkish investment and trade in the United States. To my immediate right is Roger Barton, who's was educated at Michigan and at Fordham. He's a litigator with a national reputation, also has been recognized for being one of the best lawyers in the United States, and he will and he also is involved in ADR and was formerly at Sidley and Austin, and he will talk about litigation aspects and setting up businesses, et cetera, in the United States. First, I'd turn it over to Michael.
Great. Morning, everyone. We're in New York, so I'm about to engage in a little bit of chutzpah. Thanks.
Turkish word.
Turkish word, right, well, as everyone knows. I've been representing clients based in Turkey for most of my career, early 90s. So what I'm going to talk about are a couple of observations I've made. There's no scientific basis for the observations I've selected. They relate really to my personal experience, and hence the chutzpah that my experience might be relevant to all of you here. Despite the disclaimer, I believe the observations are relevant. It is not intended to be a comprehensive discussion of the differences or the issues to which Turkish clients and you representing Turkish clients should be sensitive, but I think you can extrapolate from the discrete observations I'll make and draw broader conclusions that might assist you as you represent Turkish clients. I need my 18-year-old son for any technology, so I'm not certain. Where do I point this? Is it working? Great. All right, so two broad categories of issues I think merit your consideration. Principally, that Turkish clients might have different expectations of how legal process works here. The expectations, the differences, I think, are informed by different backgrounds, not surprising. Two broad categories of differences, one concerning systems, procedures, and the other concerning substantive laws. Again, this is not a comprehensive listing or discussion of those differences, but just a couple of illustrations. Where am I? Okay. It is the Turkish clients, I think, that you represent might be more familiar with a civil law jurisdiction. We here play with a common law history and tradition, and there are differences, and the principal difference is the role of the advocate. The civil law proceeding is one that's judge-driven. It's one in which the advocate plays, I think, a secondary role, and it is the judge who determines which witness to call, which questions to ask, and guides the process. To the extent your Turkish clients are not familiar with U.S. proceeding, I think that's something you should highlight right away, that it's the lawyer who's going to drive the process, and for that reason you are asking questions of your client that, based on a civil law experience, might not be right, might not be necessary, might be viewed as unnecessarily prophylactic or anticipatory. But as you all know, you as an advocate have an extraordinary burden, and the burden is monitored and criticized by the court, and you really need to get ahead of the game. If your clients are not much experienced in U.S. or common law proceedings, it will require a bit of effort on your part to educate and sensitize them to your needs as their representative. We can get very granular with some of the differences too. I don't propose that it's necessary at all times to do that, but some of the distinctions that have leapt out at me when I first started dealing with civil law jurisdictions was the whole idea of a trial. That a trial isn't necessarily a single event, but rather a series of hearings spaced sometimes over an extended period of time, as opposed to what we're all used to, working toward a 1 week or a 2 week trial when all the evidence is presented, all the witnesses are examined, closing speeches are given and a judgment or verdict issues in short order. In a civil law proceeding, it can be much more prolonged. This is the topic all foreign clients are aware of. U.S. is a discovery disclosure nightmare. When I encounter foreign lawyers, in particular, when I encounter foreign clients, they instantaneously express great concern about discovery, along with punitive damages and jury trials. But discovery is I think, something that is wonderful and works to the benefit of a client. But beyond that, it is something that's absolutely integral to a U.S. litigation. And foreign clients, Turkish clients that I've represented, at least initially, aren't sensitized to this. And this is something you really need to, I think, bring to the attention of your clients. Not only the breadth of discovery, not only the standard of discovery, but extraterritorial application of discovery. So if the client is here and the documents are there, the documents are going to be brought here. And that is an issue or a fact, a reality that, in my experience, foreign clients generally, and again, in my experience, Turkish clients in particular, aren't necessarily sensitive to. So again, as your role of advocate, it's something you need to bring to their attention. And when I'm talking about discovery and extraterritorial discovery, I'm not talking about Hague Convention discovery. I'm talking about nitty-gritty, prosaic litigation in the States in which your client is either here because it's initiated the proceeding, or your client is here because they have a jurisdictional presence here. Again, it's just, based on my experience, it's an issue that often surprises. It's a reality that often surprises clients. So, where am I now? Okay, I mentioned this. Everyone is fearful of juries. Everyone is fearful of punitive damages. I think, to the extent you've represented any foreign clients, any Turkish clients, it's probably an issue that's come up. I love juries. I'm not a real fan of punitive damages, but I love juries, and I think with a little bit of time, you can get your clients comfortable with that too. Why have I chosen to waste your time with those illustrations of the differences, procedural differences? All systems are different. Every system has its peculiarities. Turkish civil law, U.S. common law. Why? Because I think it's critical for all of you to manage client expectations. You're going to deal with lay clients. You're going to deal with internal counsel. You're going to deal with experts. And they really need to understand what the rules are here and how the game is played. And I'll give you one example based on my own experience that illustrates the different expectations. And to be candid with you, it wasn't something I was sensitized to until I learned the hard way. I had a case, I was on appeal. I was dealing with a very, very sophisticated Turkish lawyer, a professor. Professor Doctor was the title. This was a man who was knowledgeable, had been involved in proceedings throughout the world. When I got my argument date and the allotted time, my expert witness wanted to come over. It was his expectation that the appeal would be handled with the judges and the advocates sitting around a table like one of these, and that there would be an extensive give and take, and there would be an opportunity for the expert, who was really my co-counsel, to explain the position. And I had to tell the expert that an appeal in the U.S., certainly in New York, involves 5, maybe 10 minutes. If you're lucky, you get a question or 3 from one member of the tribunal, and that's it. And this really took me several phone calls, several hours to convince this expert, again, a very sophisticated guy, that I wasn't really trying to keep him at arm's length. I wasn't trying to keep him out of the process. It's just there was no process for him to participate in because of the way the courts run appeals, at least in New York. So those are procedural differences. Again, my goal is just to illustrate, not to go through a comprehensive list. Let's talk about a couple of substantive differences. This is also designed just to illustrate the divergence. The one with which I'm familiar, based on relatively recent experiences, is Turkey's view on bank secrecy and bank confidentiality. It is well established in Turkish law that, for example, a bank's information about a customer is sacrosanct. It is confidential. It may not be disclosed. And if it is disclosed, we're not talking about a minor fine. We're talking about the possibility of jail. So it is a serious bedrock principle of the way in which banks are to conduct their business in Turkey. In the U.S., it's just the opposite. Relatively recent, Supreme Court precedent holds that a customer has no expectation of privacy with respect to its financial information. It can be subject to a government subpoena, and it will be disclosed without any ramifications for the bank. So we're talking about completely divergent views on this significant aspect of the way in which a bank is to conduct its business. So what happens, for example, when a bank operating in Turkey is asked to turn over information about its customer relationship established in Turkey? There, the principles come into conflict, and they need to be resolved. And as you all know, there are ways of resolving these cross-border jurisdictional disputes, but I guess the money point is to highlight the issue when it first occurs, again, to sensitize the client to the differences and to prepare the client for the differences and to prepare the client for the vagaries of U.S. judges and the decisions they sometimes offer. Let's see. One more substantive difference. The extraterritorial reach of discovery in U.S. proceedings, the mere jurisdictional presence, and I apologize to the extent I'm going over very elementary principles, but again, based on my experience, these are issues that have surprised my clients from time to time. If you are involved in litigation in the U.S., if you are a party to litigation in the U.S., you are subject to the full range of discovery demands, disclosure obligations that are imposed on an entity that has no foreign contacts, that is entirely a U.S. entity. So just as a U.S. entity involved in litigation in New York would be required to produce documents located in California, a non-U.S. entity involved in litigation in New York would be required to produce documents located in Ankara. And it's this that is often a revelation to some of the clients I've represented, and it's another example of the kinds of things you need to sensitize your clients to. Judgment enforcement touches upon an area of U.S. law that is rapidly changing in New York, and because it involves, in the leading case, the hot case, a Turkish entity, I want to bring it to your attention. This is the tire engineering case, and it involves a question that in the early part of my career had been resolved. And it's an industry-specific question, so it may be of less relevance to some of you, but it relates to a broader principle, so I'm not certain I'm wasting your time. A foreign bank operating in New York, and by foreign it could be a California headquartered bank or an Ankara headquartered bank operating in New York through a branch, historically has not been required to restrain accounts located in California or located in Ankara, even if it was served with a restraining order or a judgment or other judgment enforcement devices here in New York. So to get very granular, a branch of Credit Suisse operating in New York, if served with a restraining notice, would not be required to block account that was opened in Zurich. And that was a long, well, firmly established principle under New York law. Over the last couple of years, that principle has been challenged, and right now the issue is being squarely addressed by the highest court in the state of New York at the special request of the Court of Appeals for the Second Circuit. The ancillary related issues all suggest that this bedrock principle is going to be overturned, and as a result of which Credit Suisse operating in New York will be required to block accounts domesticated in Zurich. Turkish banks, by extension, the same rule. Beyond the very narrow issue of judgment enforcement, I think you can expand to quickly reach the conclusion that any and all procedural devices, judgment enforcement or other, will be applied with equal vigor to an operation, an entity's operation, outside of the U.S. if there is a jurisdictional hook within U.S. So the idea that process or law or enforcement devices will stop at the water's edge or at the state boundary, which had a fair amount of vitality to it, I think is, well, its half-life is being reduced moment by moment. So that's another issue to which I think you should bring your Turkish clients' attention. What? Sure. I've just been given the hook. I've gone through a couple of illustrations, procedural and substantive law, differences, things that you bring to your client's attention. The purpose of which is not to qualify your clients to practice law in New York or U.S. The purpose of which is just to bring to their attention the fact that it isn't the same game. The game is different. If you're in New York, the game is different than the judicial game in Ankara or Istanbul. And in fact, the game in New York might be different from California. And that's probably the biggest burden you have, is to sensitize your clients to the prospect that things might not operate the way they're used to. Thank you.
Thanks very much, Michael. I just want to emphasize that in my experience with Turkish clients, I've had the same experience each time that Michael is talking about. And one of the lessons, I think, from that is that Turkish businesses, when they do business in the United States, have to regard going to U.S. courts as a risk, a business risk, and the underlying debt as well is a risk that they should take into account, because many lawsuits that begin in New York seeking money for goods or services delivered are settled or abandoned by Turkish clients because they don't want to continue and be subject to the kinds of problems that Michael was talking about. So thank you very much. Next we have Roger Burton. And after Roger finishes, we'll have time for, I hope we'll have time for some questions.
Thank you. The game in New York is different. We're playing football this weekend. It won't be with a round ball. Just put that out there for you all. I thought it would be helpful, particularly for the younger lawyers and really everybody in the room who hopes to practice here in the business area, to discuss what it's like to represent a foreign business that wants to establish itself in the United States. Hopefully all of you will have Turkish businesses that are going to come to you. They may be well-established large businesses, they may be entrepreneurs, but they want to do business in the United States. And I thought I'd just walk you through very carefully and in a very sort of practical way how they can do that and what to look out for. There's a number of different methods to do business in the United States. If you're a foreign company, you can acquire a company here. You can just sell your products into the U.S. You can appoint an agent to act as your representative here for your business. You can appoint a distributor or make a contract with a distributor to sell your products, an Amazon, an eBay, whatever it may be, to get your product out into the market, or an actual reseller of the product, a store, whether virtual or not. What I'm going to focus on more today is the company that wants to come in and actually form its own entity here, set up business, and own the business here. So typically that would be a subsidiary, and the subsidiary company, the owners of that are going to have a choice to make, and that's going to be, well, what am I going to be? What type of legal entity should I choose? We have 4 choices for the foreign business. One would be limited liability company. One is a C corporation. The other is a U.S. branch. The 4th is a sole proprietorship. I would only advise foreign companies to take the first 2 options. A U.S. branch is not considered a separate legal entity. You don't have protections as you do with the first 2. Sole proprietorship is the same type of analysis. There's no corporate veil that protects the entity. You're acting, in essence, on your own. Any liabilities that come about as a result of the operations in the United States would be personal to the company itself or to the individuals who are acting here. So you should choose a legal entity, and as I say, it provides liability protection. Those of us who've gone through law school, remember the corporate veil. You can, well, as long as you're acting within the corporation and not outside, you, the owner, are personally protected. It's the company and the assets in the company that are subject to risk. An LLC versus a C corporation, they are more or less the same. The biggest difference is going to be the tax treatment. And this interplays with both U.S. tax and foreign tax. A C corporation is a taxable entity. If the corporation earns profit, that profit is going to be taxed. What's left after that tax can be distributed up to the shareholders, and then they will pay tax on it again. So it's a double taxation. The LLC vehicle, which came into it's state by state, but over the last 10 or 15 years, all states have adopted it, is a pass-through entity for tax purposes, meaning that the LLC as a entity does not pay tax. The profit is sent straight up to the owners, and the owners pay tax at their level. So it's a single taxation, and in almost every jurisdiction that means you're going to pay less in tax. There are times, however, when you might want the C corporation because it's a little bit cheaper to set up, particularly for a small business, and many U.S. businesses that are set up by foreign companies are expected to lose money for a long period of time, so nobody cares about paying tax on profit because they don't expect to have tax on profit. So that's, a little nuance to discuss, but most of the time for our clients we set up the LLC. Where to form the LLC? We have many different states in the United States. Each state has its own LLC law. If you form an LLC, you do it under state law. You register with the Secretary of State of that state. So which one do you choose? You can choose any state you want. There's no requirement that says you need Delaware or Nevada or New York or whatever. You can choose any one that you want. The considerations to think about are where's your base of operations going to be, and the quality of the corporate law in that state, and particularly the courts that sit in that state, because if there's a dispute, more likely than not, that's where you're going to fight it out. So you want a more developed area. Typically, we suggest either New York, Delaware, or sometimes Nevada. However, regardless of where you form the entity, you have to also consider where the business activities will take place. So if a company comes in and says, I'm going to have a headquarters in New York, but I want to be a Delaware LLC, we can do that. And we'll form them in Delaware, but we need to authorize them to do business in New York. It's a separate filing that doesn't make them a New York corporation, but it gives them the authority to do business in New York, which in essence gives them the authority to use the court system in New York if they have a dispute with someone. If they are not authorized to do business in New York, they cannot make use of the New York courts. What does it look like? This is a typical structure that we put together. The foreign company can sit anywhere. Foreign means foreign outside the United States, foreign in a different state, whatever. For this purposes, let's say foreign companies in Turkey. Typically, the Turkish company will own either 100% of the U.S. LLC, which makes it a single member LLC,